The federal government just admitted that suppressors are protected by the Second Amendment, and then in the very same breath told you that you still can't have one without jumping through every bureaucratic hoop they've set up since 1934. That contradiction is now sitting on the doorstep of the highest court in the land, and what happens next could reshape firearms law in ways we haven't seen in years. Let me walk you through exactly how we got here, what's being argued, and why this case matters far beyond just suppressors. This all centers on a case called U.S. versus Peterson, and it has been building momentum for several years now. To understand why this petition landing at the Supreme Court is such a significant moment, we need to go back to where this story begins, in Louisiana, back in 2022. That year, federal and state law enforcement officers executed warrants at the property of a man named Mr. Peterson. During the course of that search, officers recovered a solvent trap. Now, for those unfamiliar, a solvent trap is a cleaning device used for firearm maintenance. However, the government classified this particular item as a suppressor under the National Firearms Act. That classification triggered serious federal charges. Mr. Peterson was charged with possession of an unregistered suppressor, a violation of the NFA, which requires every suppressor in the country to be registered and taxed before a civilian can legally possess one. Mr. Peterson's legal team didn't simply accept that charge. They fought back with a constitutional argument. They filed a motion to dismiss the charge entirely, arguing that the NFA's registration and taxation scheme as applied to suppressors directly violates the Second Amendment. This wasn't a procedural technicality or some narrow legal maneuver. This was a full-throated constitutional challenge against one of the oldest federal firearms laws on the books, and the district court wasn't having it. The trial-level judge rejected the argument outright, and the conviction moved forward. But the legal team wasn't done. They appealed, and this is where things started to get very interesting. The case traveled up to the Fifth Circuit Court of Appeals, one of the most influential appellate courts in the country. Initially, a 3-judge panel at the Fifth Circuit looked at this case and ruled that suppressors are not even protected arms under the Second Amendment at all. Think about that for a moment. The court's position was that suppressors fall entirely outside the scope of constitutional protection. Under that reasoning, the government could regulate them however it wanted, ban them outright, tax them into oblivion, require any registration scheme it felt like imposing, because according to that initial ruling, the Second Amendment simply didn't apply. But then something happened that fundamentally altered the trajectory of this case. The Department of Justice under the current administration made a stunning reversal. The Trump DOJ officially changed its legal position and conceded that suppressors are, in fact, arms protected by the Second Amendment. This was not a minor footnote buried in a legal brief. This was the federal government's own lawyers standing up and saying that their previous argument was wrong. Suppressors are constitutionally protected. That concession forced the Fifth Circuit to withdraw its original opinion entirely. The court had to go back to the drawing board and issue a new ruling because the foundational premise of the first decision had been pulled out from underneath it. Here's where the legal reasoning took a turn that has generated enormous controversy and is the primary reason this case is now before the Supreme Court. When the Fifth Circuit issued its revised opinion, it acknowledged the government's concession. The court assumed for the sake of its analysis that suppressors are indeed protected arms under the Second Amendment, but it still upheld the NFA. The court's new reasoning was that the NFA's suppressor registration system functions essentially as a shall-issue permitting scheme. In plain terms, the court said that because the NFA process is technically objective, because the government doesn't exercise subjective discretion in deciding who gets approved, the system operates more like a permit than an outright ban, and permitting schemes under certain legal frameworks can be constitutional even when they regulate protected rights. This is the legal reasoning that has set off alarm bells among Second Amendment scholars and advocates across the country, and for very good reason. The implications of that logic extend far beyond suppressors. If a federal court can uphold a registration and taxation requirement on a constitutionally protected arm simply by relabeling it as a licensing scheme, that same logic could theoretically be applied to virtually any firearm. Handguns, rifles, shotguns, every category of arm that the Second Amendment protects could potentially be subjected to the same treatment. register it, tax it, create a federal database tracking ownership, and as long as the bureaucratic process is technically objective, the court says it passes constitutional muster. That is an extraordinary amount of power to hand to the federal government over a fundamental constitutional right, and that brings us to the present moment. Mr. Peterson's legal team has now officially filed a petition for certiorari with the United States Supreme Court. This is the formal mechanism by which a party asks the Supreme Court to review a lower court's decision. The petition presents two core questions that the justices are being asked to resolve. First, can the NFA's taxation and registration system legitimately be characterized as a licensing law under existing Second Amendment precedent? And second, does the NFA violate the Second Amendment as applied to suppressors? These are not narrow technical questions. These are foundational questions about the limits of federal power over the right to keep and bear arms. The petition itself lays out several powerful arguments. The first and perhaps most critical argument is that the Fifth Circuit committed a fundamental analytical error by conflating two very different concepts: registration and licensing. These are not the same thing, and treating them as interchangeable has serious consequences. A licensing system, in the traditional sense, is a verification mechanism. It confirms that an individual meets certain criteria, typically that they are a law-abiding citizen, before allowing them to exercise a right. We see this with concealed carry permits in many states. You apply, you pass a background check, you receive your permit. The system verifies eligibility. A registration system is something entirely different. Registration creates a government database that tracks who owns what. It doesn't verify eligibility so much as it catalogs possession. The NFA doesn't merely ask whether you're allowed to own a suppressor. It creates a permanent federal record that you own one, tied to your name, your address, and the specific item's serial number. The petition argues that the Fifth Circuit improperly merged these two distinct concepts and in doing so allowed the government to sidestep the historical tradition test that the Supreme Court established in the Bruin decision. Under Bruin, once the Second Amendment is found to apply to a particular arm or activity, the government bears the burden of demonstrating that its regulation is consistent with the historical tradition of firearms regulation in this country. The government has to point to historical analogs, laws from the founding era, or the period surrounding the ratification of the 14th Amendment that are relevantly similar to the modern regulation being challenged. The Fifth Circuit never conducted that analysis. It never examined whether there was any historical tradition of requiring Americans to register their privately owned arms with the government. It simply looked at the NFA, decided it resembled a licensing system, and declared it constitutional. The petition argues that this approach directly contradicts the analytical framework that Bruin requires. The second major argument in the petition targets the NFA tax itself, and this is where the historical context becomes particularly revealing. When the NFA was enacted in 1934, the tax imposed on items like suppressors was set at $200 in 1934 dollars. Adjusted for inflation, that amount is roughly equivalent to $4,800 in today's money. The petition argues, and this is a compelling point, that this tax was never designed to raise revenue. It was designed to make ownership prohibitively expensive for ordinary Americans. It was a financial barrier deliberately calibrated to suppress the exercise of a constitutional right. The Supreme Court has a long and well-established history of striking down taxes that target the exercise of fundamental rights. The court has invalidated taxes on speech under the First Amendment. It has struck down poll taxes that condition the right to vote on payment. It has rejected taxes specifically targeting newspapers and media organizations. The principle running through all of these cases is consistent and clear. The government cannot use its taxing power to burden the exercise of a constitutional right. The petition argues that the NFA tax on suppressors is no different. If the Second Amendment is a fundamental individual right, and the Supreme Court has confirmed multiple times that it is, then the government cannot single out the exercise of that right for punitive taxation. The third pillar of the petition addresses the historical tradition question head-on. The founding generation, the people who wrote and ratified the Second Amendment, did not require Americans to register their firearms with any government authority. There was no federal arms registry. There was no state arms registry. The concept of the government maintaining a comprehensive database of privately owned weapons would have been deeply alarming to the people who had just fought a revolution against a government that attempted to disarm them. The petition makes the provocative but historically grounded argument that if the British Crown had attempted to impose a firearms registration scheme on the American colonies, it would have provoked even greater resistance than the measures that actually triggered the revolution. Under Bruin's framework, the absence of any historical analog is not just notable, it is dispositive. If the government cannot identify a historical tradition supporting the regulation fails. The petition also raises a critical structural concern about the Fifth Circuit's ruling, one that should worry anyone who cares about the limits of government power, regardless of where they fall on the political spectrum. The Fifth Circuit's opinion contains no limiting principle. If the NFA can survive constitutional scrutiny simply because the court labels it a shall-issue permitting scheme, what stops the federal government from applying the same logic to every category of firearm? What prevents Congress from enacting a National Firearms Registration Act that requires every gun owner in America to register every weapon they own, pay a tax on each one, and submit to a federal tracking database? Under the Fifth Circuit's reasoning, as long as the approval process is technically objective, such a system would be constitutional. The petition argues that this outcome is incompatible with the Second Amendment as understood by the Supreme Court. So what happens from here? Now that the petition has been officially filed, the case enters the Supreme Court's review process. The federal government will have an opportunity to file a response brief, likely defending the Fifth Circuit's ruling and arguing that the Supreme Court should decline to take the case. After briefing is complete, the justices will conference and decide whether to grant certiorari. It takes the votes of 4 justices to accept a case for review. If the court grants cert, this case would become one of the most significant Second Amendment cases since Bruin itself, because it would force the court to directly address the constitutionality of the NFA's framework as applied to constitutionally protected arms. There are also other NFA-related cases working their way through the federal courts right now, and those cases could potentially influence how the Supreme Court approaches this petition. The justices may choose to wait and see how those cases develop, or they may decide that the questions presented in this petition are important enough to warrant immediate review. Either way, the legal landscape surrounding the NFA is shifting in ways that would have been difficult to predict even a few years ago. The government's own concession that suppressors are protected arms is a genie that cannot be put back in the bottle. That admission has fundamentally changed the legal calculus, and whatever the Supreme Court ultimately decides, the arguments raised in this petition will shape the debate over federal firearms regulation for years to come. This is a case worth watching closely. The outcome won't just determine whether one man in Louisiana can possess a solvent trap without federal prosecution. It will determine how far the federal government can go in regulating, registering, and taxing arms that the Constitution explicitly protects. The stakes are enormous, and the legal arguments on both sides are now fully joined. That's it for today, folks. See you in the next video.